the end of the day, what I think lawyers really do for people is help them solve problems. That's really what lawyers should be doing for people. And in the context of wills and planning for the end of life, that is a problem. That is an issue people need help solving. And so we try and help people come up with simple solutions that make their life easier, not complicated.
Today, our guest is Jason Cordoba with the Cordoba Law Firm. And Jason is a local attorney. He is very involved in our community. He's, believe you're the board president or board of
Chairman.
regents chairman
Yeah.
for the college. You're involved in a lot of our local boards as well, Chamber of Commerce. You've been involved in Rotary. I mean, just you can go on and on. Your reputation precedes you here in Brazoria County. You've even taken cases up to the Supreme Court. So welcome to our podcast, Jason.
Thank you. Appreciate it. Good to be here.
Man, I'm so excited to have you here as a friend of mine, as somebody who represents me and have done my will, my trust, and each one of my business transactions and property purchases that I've done. I trust you, and this whole podcast is about developing trust, or people who already trust us, seniors and families who are looking for people obviously they can trust. But there's so many questions people have.
Sure.
I get questions on wills and trust and deeds and things that are nowhere near my expertise. So we come to you so many times.
Well, I appreciate that.
So with all your expertises, you do business law, you do real estate law, you do wills and trust, you do litigation for different things. What do you think is the most important thing, especially talking about wills and probate, that people should know? And then we're going to dive into some of those things.
Whenever I am helping a client with any kind of legal matter, business, real estate, estate planning, I think the most important thing for me is I want to know what their goals are. And I think what my job is as a lawyer is to help them figure out what is the easiest path to that goal. I've never had a client tell me to make it as expensive and complicated as possible. They want it easy. And so by knowing their goals, I really take a lot of pride, and the other attorneys at my firm take a lot of pride in trying to get to that goal as easy as possible. Because at the end of the day, what I think lawyers really do for people is help them solve problems. That's really what lawyers should be doing for people. And in the context of wills and planning for the end of life, that is a problem. That is an issue people need help solving. And so we try and help people come up with simple solutions that make their life easier, not complicated.
Yeah, that's good. You know, death is uncomfortable to talk about when you're still alive.
Yeah.
But we have to have these conversations. That's the one thing we're not going to get out of, paying taxes and death. And so helping people deal with that and prepare for it is really important. Taking care of your family, your children, and that changes as well. So how you help manage that is important. What are some misconceptions that people may have about a will or probate and even trust? What are some important things about those things, and what are some common misconceptions that people may have?
I think one really big misconceptions that a lot of people have is take most estates in our community. A lot of estates in our community are somebody owns a home and then they have a retirement account and then they have some bank accounts. That's a very, very common estate. And a lot of times people mistakenly believe that because the husband and wife are on the deed to the house, that whoever the survivor is, the house automatically goes to them. And that's not the way it is. Maybe it should be that way, but it's not that way. And so sometimes people think we just had the house, we're both on the deed, it automatically goes to the surviving spouse. And that's not necessarily the case. It's not like a joint with rider survivorship bank account. You have one of those, that's beautiful because it immediately goes to whoever the survivor is. The house isn't like that. So that's a really big misconception that people make, and oftentimes they don't realize that mistake until the surviving spouse or the kids one day down the road go to sell the house and there's a title problem as a result of that first passing. And so that's a huge misconception that people make. Another thing that we deal with a lot is there's a lot of information online about trusts and wills. And so I have a lot of conversations with people about whether they need a trust or not. And so when people go online and they read things, a lot of people see things that make them believe I need a trust. And I always ask them, why do you think you need that? What did you hear that makes you think you need that. And we'll do whatever a client wants. Our job is to provide a service to them. If a client really wants a trust, we will do it. But oftentimes I find that people learn things online that may not necessarily be true in Texas. These laws are different from state to state, which makes it even more complicated. And so the people sometimes that they're hearing about online may be telling them things that make total sense in California, may make sense in
Wow.
Massachusetts, but not in Texas. And so I ask clients, well, why do you think you need a trust? And they'll tell me things like, well, I want to avoid probate, which is not a bad goal to have. The problem is having a trust doesn't guarantee that you will avoid probate, which is why every time somebody does a trust, there's also a pour over will that accompanies that trust. And so what that pour over will does is it basically says that when you pass away, if there's some asset you own that's not in your trust, you have to go through probate to probate that pour over will to pour everything into the trust. And so I would say 2 out of 5, 3 out of 5 trust based plans that I deal with when somebody passes away, I still end up having to do a form of probate. And so it's really misleading to people when they see online that you can avoid probate. The reality is you might avoid probate. And so it's no guarantee. And then, people pay a lot of money for those trusts and they do it banking on the fact there will be no probate. And that's just not true. It's not a guarantee, I should say. So that's a big misconception. And then another really big misconception staying on this trust issue is people feel that if they have their homestead in a trust that it's protected. And that's not true either. The reality is in Texas, your homestead is constitutionally protected from creditors. So, what that means is there's nothing any lawyer can ever do for you to make your home any more protected than it already is by virtue of it being your homestead.
Okay.
And so, that's a really false thing that I think people see. And that may be true in other places. But in Texas, there's nothing that a lawyer can do for you to protect your home any more than it already is by virtue of it being your homestead. And so those are a couple of big ones that I typically deal with. Try and explain that to clients and make sure they understand that so that they don't pay us a lot of money for something that doesn't bring them a whole lot of value.
Right.
Yeah.
Right. I heard my CPA said something about is the juice worth the squeeze? And so kind of that's the thought you have to have. Is it worth it? Is it not worth it? As we go through wills and probate, and we've had these discussions, one of my concerns is that I do have debt to creditors, debt to the bank. And when I die, obviously I have life insurance. How does that get managed? Does my conservator manage that? Who manages that when I'm dead so that I can be more at peace that they don't have to work so hard? I'm trying to make their life better when I die and not more complicated.
Yeah, so typically what happens regarding debt when people die, it kind of depends on what kind of debt it is. There's secured creditor debt and unsecured creditor debt. So unsecured creditor debt is really common. That's your credit card debt, that's your hospital bills, your ambulance bills. The reason it's called unsecured is because there's no collateral for that debt.
Okay.
So those creditors are handled one way. The other creditors that exist are secured creditors. These are the creditors that have a lien on your house because you got your mortgage through the bank, your lien on your car because you borrowed money to buy your car. Those creditors have a much stronger standing when you pass away. Those creditors they're either going to get paid or they're going to get their collateral. Either way. And so oftentimes the big issue for people are homes. Their home has a mortgage on it. My spouse passed away. We had a mortgage on a house. How do I handle the bank and the mortgage? The unfortunate thing that I have to tell people in that situation is that technically an event of default is when you die. So everybody knows it's an event of default on your loan if you don't pay them every month, but most people don't realize that it's an event of default when you die. It specifically says that a default is you don't pay this note and if you die. And so that can put a surviving spouse in a bad spot sometimes because if, for example, what we run into a lot of times is the husband really was the basis. His income was the basis for the loan. Maybe wife's a stay-at-home mom. She's technically in default when husband passes away. How in the world can she qualify to refinance his house? And so that's a really tricky situation that we have to advise clients on pretty carefully because I don't want to put them in a spot where that surviving spouse is now sideways with the mortgage company. And so there's some things that we do to kind of help manage that. to not put that surviving spouse in a bad spot. It's always unfortunate though when the surviving spouse comes to me and they tell me, I already told the mortgage company. I'm like, probably wouldn't have told them quite yet. So that's an unfortunate situation. Now, jumping over to the other end of the spectrum, back to those unsecured creditors. This is your credit card bills. These are your hospital bills. Those bills, those we have to deal with those in the probate context. But most of those creditors never get paid. I would say 95% of them do not get paid. And the reason they don't get paid is because either A, there's no money in the estate to pay them, or B, the creditor doesn't go through the process correctly to get paid. There's hoops they have to jump through. And if they don't jump through them correctly, we don't pay them.
Wow, that makes a lot of sense. There's a whole lot. And that's the reason, I think it's important to have an attorney to walk you through these things. But I want to switch gears a little bit. So there's a lot there, and people really need to come see you. They really do. They need to follow up with their attorney. I think another thing that's important on wills and owning property is you can have a great will in Texas, but you own property in other states. Now, that could wind up having you in court in probate in multiple states. Is that correct?
Yeah. So that that scenario is a little tricky to deal with, and we deal with it in one of two ways. One way that we will deal with it is we will put that property in another state in a trust, just that asset. So it kind of goes outside of probate.
Okay.
And so that's one way that we can handle that situation. The other situation is we just leave it and we have a will in Texas. We do a probate in Texas. And then what happens is it does sound, when you say it, like a total nightmare having to deal with another probate process in another state. However, it's pretty streamlined because basically what happens is we go through a simple probate process in Texas. We take all those probate documents in Texas, we file them in the state where that real estate is, and it's typically like a walkthrough situation where an attorney there basically gets the court to bless the authority of the executor in that state. Then the executor has authority to sign a deed conveying it to whoever the beneficiaries are under the will. So it's not optimal and it's not great. However, it's a fairly easy process, I found. And then sometimes we can even avoid the probate process in that other state, depending on what state it is. But you're right. And it's kind of like it's almost like a backhanded compliment, Shame on you you almost feel like you're getting punished for owning real estate in another place. Yeah. And it shouldn't be that way. It should be easier for people, but unfortunately the law doesn't shake out in a very user-friendly way on those situations.
Yeah, that's interesting. And again, you see some of this stuff on the internet, you see it online, you see even the TikToks that are covering different things that are probably not necessarily true in Texas. So, wherever you are, whatever state you're in, you should probably have an attorney who's helping you navigate those things.
There's one thing that I tell clients whenever they see things online, and I welcome my clients to read. Every client's different. Some clients want to learn everything they can learn. Some clients just want to come in and get advice and do whatever we recommend. Every client's different. It's important to me that I want my client to understand as much as they want to understand. But one of the things I tell them that they have to remember on all these things they see online is somebody's trying to sell you something.
Right.
They're trying to sell a product that you might or might not need. Or maybe they're not giving you all the facts. It's just like anything else. And so we take a lot of pride in being small town lawyers that, get to look people directly in the eye and try and come up with something that really makes sense for them, not us, but for them.
Right. And you take the time to do that. And it's so important, especially, we're in a small community and you don't just represent Lake Jackson. You go all of Brazoria County for sure and outside of that area. So having an attorney people can trust is super important. And that leads us into, I think, my next topic that I want to discuss with you that we didn't really talk about because I want to hear every bit of this. But there are instruments because what we really want to do is make sure that this is the Senior Life Network podcast. So I want to prepare seniors. I want to prepare family members as they're dealing with their parents, with their family, with their spouses. And there are a lot of instruments, documents that are a little confusing. So I want to talk a little bit about the different kinds of powers of attorney that people should be looking into while people are have capacity and then what happens when they lose capacity. So can you talk a little bit about power of attorney, durable power of attorney, the different ones that are out there?
Yeah. So there's kind of a standard estate planning package that lawyers have been doing for people since the beginning of time. And so nothing about what I'm about to explain is creative or is us. Okay, this is kind of industry standard. Typically, it's a last will and testament or a trust, but more often a will. There is the financial power of attorney. There is the medical power of attorney. There is a directive to physicians. And then a fifth document that's very common is a HIPAA authorization. And then occasionally there is another document called a designation of guardian in the event of need. And so typically what we do for people are four. We do the will, we do the financial power of attorney, we do the medical power of attorney, and the directive. Actually, there's fifth. The HIPAA is one we do as a courtesy for clients. So we'll start with the financial power of attorney. The title of that document actually is statutory durable power of attorney. And I tell clients all the time, I don't know why they call it that. I don't know why they just don't call it a financial power of attorney, because nobody knows what the heck statutory durable means, but it's a financial power of attorney. So that's a document where you can appoint somebody to make financial decisions for you if you're ever unable to make those decisions during your life. And so that document is only effective while you're alive. And so when we talk about financial decisions, what I'm talking about is basically anything that's not medical: banking, utility bills, insurance, taxes, real estate, you name it. If you can sign your name there, that's what the financial power of attorney authorizes somebody to do. So it's a big deal. You're giving somebody an extraordinary amount of authority to act on your behalf. But the flip side of that is, with all this authority you're giving them, that person owes you a fiduciary duty to always act in your best interest. And so a fiduciary duty is the highest duty you could ever owe another human being under the law. And so that's a big job. That word power of attorney gets thrown around a lot, but it's a big deal. You're authorizing somebody to take money out of your bank account, buy real estate in your name, sell real estate. I mean, it's a really, really big deal. However, it's an incredible tool that your family can have if you're ever unable to make your own decisions. And so that's a really, really important document. The other document, power of attorney, is the medical power of attorney. So same basic concept, but of course for medical stuff. And so these documents, though, they work slightly different. The financial power of attorney can be effective immediately when you sign it. It doesn't have to be effective upon your incapacity. You can make it effective immediately, which is what most lawyers who do this regularly understand, that really the best way to do it is to make it effective immediately, as opposed to in the future upon your incapacity. And the reason why is because incapacity can be a really big gray area. So if you make your financial power of attorney effective upon your incapacity, if you're one of these folks that lands in a spot where you're good today and bad tomorrow, or you're good in the morning but bad in the afternoon, I don't know if that thing's effective or not. So most lawyers who do this regularly, who kind of have dealt with incapacity issues at the courthouse, understand that make it effective immediately. You can change it if you want to, as long as you have capacity, but that typically is the way to go. That's what we recommend to almost every client. Very few exceptions to that. The medical power of attorney is a little different. The medical power of attorney really is about informed consent. That's, of course, where the doctor is explaining to you a recommended medical procedure, all the risks that go along with it, the rehabilitation time, all of that. And if you're okay with all that, you sign off on it, right? Okay. Well, if the doctor is ever explaining something to you and you cannot understand he or she, because you have some horrible disease like dementia or Alzheimer's or one of those things, the doctor shouldn't be shoving pieces of paper in front of you, right?
Exactly, yes.
So if that happens, the doctor should not rely on your consent, but your power of attorney can make that consent on your behalf.
Okay.
And so a couple other things with the medical power of attorney that we think are important. The medical power of attorney is typically not for emergency situations. If you get in a really bad car accident and you're unconscious or barely conscious, the EMS people, they don't ask for your permission, right?
Right. They haven't assumed consent.
Exactly.
Yes.
Same thing at the hospital. So the medical power of attorney typically it's not applicable in an emergency situation. You have an emergency, they're going to help you. That's just the way it works. And then,
well, let me stick on that just a second.
Sure.
So this is a medical power of attorney.
Mm-hmm.
Is there a difference? Is it just terminology, or is advanced directives different than that?
Yeah, that's one of the things that's confusing to people is that these terms, you might read 5 different things online and people think there's 20 documents or it's confusing. So the next document is the directive to physicians. And so that is the one that I tell clients all the time. This is the least fun to talk about. None of these are fun to talk about. This one is the least fun to talk about because this is the way I explain it to clients. If you sign a directive to physicians and you indicate certain selections in that document, what you're telling your physician is if I'm ever in a bad spot medically, I want CPR, I want medicine, I want procedure, and after you traumatize me with whatever procedure you just put me through, I may need to be on life support to recover from that. However, after you do all those things, if the only chance I'm going to have to be alive forever is to be on a machine forever, well, if that happens, that's not what I want.
Right.
In that case, I want to be kept comfortable but removed from the machine. So the directive to physicians oftentimes gets confused with something called a DNR, do not resuscitate.
Right.
If you have a DNR, doctors do nothing for you. They do nothing. They watch you pass away. So what I find most of our clients want is, help me if you can help me. I just don't want to be on a machine forever.
Exactly.
But occasionally clients will come to us and they might have a quality of life issue that's so poor that they really do need a DNR.
Absolutely.
That really is what they need. And in that case, we don't even charge clients for the DNR. It's a state form. We print it out and we have them sign it. And, people are in such a bad spot in life. Like that's an easy thing for us to do as a law firm. So we just do that for people in the rare instances where it's applicable.
Yeah. The DNR has to have a witness, typically a family member, but you can sign that. A physician typically signs it. And that is different. That is more, I think, especially as somebody who served for 30 years in EMS, we resuscitate a lot of people, 60 years old, 70 years old from a cardiac arrest, maybe even 80, and they go on to live a normal life. Had they had that DNR, we couldn't have done it. So I think reserving that DNR for people who are already on hospice, but truly understanding what the DNR is. We resuscitated somebody 75 years old who had a DNR. No, I'm saying he was 55 years old. He had a DNR. But we resuscitated him because they didn't present the DNR. And he went on, he's still alive today. And they did away with the DNR because they understood, hey, this is not exactly what I thought it was. And that gets back to your directive to physicians more than the DNR. Anyone on hospice, they've been found to be terminal. They probably need a DNR. And there are many other quality of life issues that need a DNR, but not everyone needs that. And if you're my age, boy, I want CPR. I want to be resuscitated. But I don't want to live on life support my entire life.
Yeah, I can't tell you how many clients I've met with, and we start talking about these incapacity documents, and I get to the directive DNR, and the client will say, I already have a DNR. And I'll ask them, well, how did that come to be? And they'll say, I found it online through the Texas Department of Health and Human Services or whatever it is. And I filled it out and I'm good. And I asked them, do you know what that document does? And once I explain it to them, I've had several clients that kind of their eyes got this big and they're like, no, that's not what I want. I want them to help me if they can. I just don't want to be on a machine forever. And so we've had a couple of instances where we had the opportunity to explain it to people and they understood what they really wanted. It wasn't a document, and it shouldn't be that complicated for people. People shouldn't have to hire lawyers to make sure that's right. People shouldn't have to hire lawyers to get stuff to their spouse or their kids when they die. But unfortunately, the way the law shakes out, people oftentimes need that help. And so I also tell people what I do is not an IQ thing. You're probably smarter than me, but this is what I do every day. I see it go right. I see it go wrong. And so we take a lot of pride in helping people kind of get to where they want to be.
That's so important that you do that. And, that's why this podcast exists. I've been in healthcare my entire life. That's all I've done. And I just continuously see these gaps, these breakdowns, these misunderstandings. And then again, not because somebody's not smart, but just because they don't know. And I've been around it so much that I'm probably worse off than a lot of these people because I think I know stuff, and it gets very confusing even to myself as I'm trying to navigate people's lives with their families, and I want to do it right. And that's why I refer so many people to different attorneys or back to their own attorney. Have conversations with the physicians. We walk in and we try to advocate for patients. So we want to have conversations with the physicians, with the families, so that we can make sure that they are getting what they actually want. That we, number one, understand what the problem is, what the medical condition is, if it's going to be terminal, if it's a quality of life issue, or if we're going to get them better and get them back really quickly. All of these things we need to start thinking in the future. We need to start thinking about how we protect them.
Yeah. I thought about another thing that I see quite a bit in my job, and it's when people download things online and they sign them. And so when people call me and they're telling me about a legal situation, any type, and they tell me they downloaded something, whether it's a contract, a will, a power of attorney, it doesn't matter, whatever it is, and they're telling me this over the phone, I get really nervous because there's so many things that people can download and sign that may not work. Sometimes I wish people would have done nothing, because sometimes having nothing is better than what they actually signed.
Wow.
And so, and again, it shouldn't be that way. It should be easy for people. They shouldn't have to hire a lawyer, but probating wills that somebody downloaded online, the people ask me this, well, is it going to work or is it not going to work? And I give them the best answer I can give them. It might work. It might not work. And I tell them it's not fair, but that's the way it is. And oftentimes when those wills do work, the process is more complicated, more expensive, and more time consuming, because some ridiculous technicality that somebody decided was important under the law wasn't met. And so those are tough conversations to have with people, and they feel really good about it because they got it in writing and it was notarized and they think that they're golden. And unfortunately, sometimes it's not the case. Sometimes it works out, sometimes it doesn't. So
Wow. That's a lot of information, and we're scratching the surface of the things. Again, my hope is to just be a resource. Say these are great topics. Go talk to your lawyer, Jason. What does, and I know there's always going to be a range. Obviously, different attorneys charge different amounts, different expertise. You've been doing this a long time. What I don't really know how to ask this, but what does it cost, or what would the savings be? Maybe both. If you went and spent some time with an attorney, got these documents done up front, ready, come back every 6 months, every year, every time assets change, rather than having to go into the entire probate process.
yeah, so first of all, understand that a will does not help you avoid probate.
Okay.
What a will does is it helps make that process easier, faster, and less expensive. The other thing that a will does is a will dictates really basically two things. One, who's in charge, and two, who inherits my estate. If you don't have a will, the law dictates who's in charge. The law dictates who gets your stuff. And we live in a place and a state where most of us desire to control that, not the government. And so a will is your opportunity to tell the world who's in charge of my estate and who inherits it. You can give your stuff to whoever you want to in this state. The cost to do a will is a flat rate of $650. And so all lawyers do this differently. But the way it works at our firm is that you meet with an attorney and we go over what your needs are and what your wishes are. We draft them, and then you have a second meeting with an attorney to go over it and to make any changes and to sign it. And so for $650, you get a meeting with a lawyer twice. You can call the lawyer in between those meetings, and you get a document that will work at the courthouse to go through probate.
That's amazing. And it's not cookie cutter. Each one that you do is individual towards that person, that family, their wants and their needs.
Yeah, it is. But I will tell you what a lot of people in our community like, and it's everybody's different, but wills can be as simple as for husband and wife. Everything goes to my spouse when I pass away. Then we want everything to go to our kids in equal shares. That is the most common will that we do, and probably most lawyers in our community do. But sometimes people need a little different. Sometimes people have blended families. Sometimes people have an inheritance that they got from several generations that they want to stay in the bloodline and go to their children and kind of skip the spouse. And so, there's all kinds of variations of that. But at the end of the day, what we want to do is figure out what a client wants, and we want to draft it in a way that they will understand when they go home, And that one day, if it has to go through probate, a court will understand. Sometimes I look at wills that are so complicated, it takes me like 4 or 5 times to read it, and I do this every day. And we don't want that. That's too complicated. We need to be able to read it and understand it the first time. And so we try and draft whatever their wishes are in a way that's understandable and it's clear.
Yeah. Let me ask you this. Do you think, Jason, do you think it's important that once you sit, I come in and sit with you, we draft up this will, you and I, or if I was married, my spouse, you and I sit and we draft the will. How important do you think it is to sit with the family afterwards, your children, if you had a second marriage and children from a different marriage, how important is it to discuss what you just put in writing?
Every situation's different. But when parents do something that they feel is going to cause some friction in the family, my general recommendation to those folks is tell your kids what you're doing. Because if you don't, and you don't have to, but if you don't, it's going to be somebody else's problem. And so you take, for example, let's say parents want to name one kid as the executor, or parents want to give more of the estate than other kids. My general recommendation is tell your kids, because, for example, if you're going to give more of your estate to kid A than kid B, if you don't tell kid B, it's going to be kid A's problem to deal with, because it will be a problem. But you're making kid A's life so much easier if you just kind of tell them up front, these are your wishes. The other thing that helps avoid is, will contests, because then it's crystal clear. This is what mom and dad wanted. This isn't what kid A wanted. This was mom and dad's wishes. And so I typically will encourage my clients to tell their family what they're doing, especially if it's a little different. When everything goes to the kids in equal shares, kids could complain, but complaining about equal is pretty tough.
Yeah.
So I typically encourage them to do that because I've seen when parents don't. And I've talked to the child who maybe received more of the estate when mom and dad have passed away. I hear what they're having to deal with from their other sibling, and that's tough. They shouldn't be in that spot. So does that answer the question?
No, that's great. I think that's really important. I do believe you should go have that conversation, because again, even in what we do at Help Inc. and caring for seniors every day, we walk into this as families are trying to navigate it, and you see family members who once just loved each other wind up in turmoil, and it's heartbreaking to see this. It's heartbreaking for the parents, the surviving spouse, and even to see that these children have gone to battle. And I think some of this could prevent some of these wars that happen.
I'll tell you what I see in regard to that situation. Sometimes what we see in that situation is somebody is just not a happy person. They weren't happy before, they're not happy now.
Yeah.
That just happens. But the other thing that I find happens too is that, I think the thing to remember, and I tell our attorneys this at our firm, is you got to remember somebody lost a loved one.
Mm-hmm.
And what happens when people lose a loved one oftentimes is people are emotional. And when they become emotional, sometimes we become unreasonable. And then that gets exacerbated by the fact that when people are going through that, all of a sudden everybody in their life is a probate lawyer, telling them what they need to do. You need to do this. You need to do that. And that can be really draining on that person who's already kind of emotionally hurt. They lost their loved one, and then they got people who they love telling them what they need to do who have no idea what they're talking about. And all of that just can add to friction. And so part of the thing that we try and think through when we're creating plans for people is I'll ask questions about that. There's certain planning that we can do that can make life easier. But if kids don't get along, or if somebody is unreasonable, then that plan may not work. So we try and help people think through that.
Yeah, that's great. So much great information. And we're scratching the surface. But as we conclude this podcast or this episode, what is one thing that you would say, walk away from this podcast understanding this?
Yeah, I hope this doesn't sound self-serving, but the biggest recommendation that I can give to people is confer with an attorney. You don't even have to hire them. Just go get the information from an attorney on what you should do, and then you can decide whether you want to hire them or not. But at least go get that information from somebody in your community, or even if it's in Houston, if you really want to, on what you should do. And then you can make a decision, because that advice undoubtedly is going to be better, almost undoubtedly is going to be better than what you read online or what you heard on YouTube. That's personal. That's somebody who actually goes to the courthouse monthly, weekly, or whatever, and understands exactly how this stuff works, not only in the state of Texas, but in our county. And then you can decide. And I tell clients this all the time, a lawyer needs to make sense for you. Not every lawyer is a good fit for every person.
Yeah.
People, and so I think I encourage clients, if you're going to go meet with an attorney about something, go with your gut. How do you feel about this person? Do they seem knowledgeable? Do they care about me as a human being? I think all those things are really, really important. And so the biggest advice that I can give to people is confer with some attorney on what you should do, and then you can decide. And if you want to go visit with 2 or 3 attorneys, you can do that. And then you're gathering all the information that you can gather from people that do this every single day, hopefully, and help you come up with a good plan for you and your family.
Yeah. Being informed before the crisis is really important. So
one of the things that we tell people all the time is all lawyers are expensive. Even bad lawyers are expensive. But every lawyer is more expensive after the problem than before the problem.
That's really good.
And it's really unfortunate when situations in a state become a total disaster that could have been avoided with a $650 will.
Wow. Yeah. So good. Well, thank you for joining us, Jason. And we're going to have a link below how people can reach your law firm and reach out to you. So thanks a lot for being here today.
Thanks for having me.
Today's episode was sponsored by Riviera Eves Law, PLLC.